Hello, I'm Michael Buck. I'm an Australian patent and trademark attorney, and today I'd like to tell you a little bit about entering the national phase in Australia and about the situation with amendments, national phase entry requirements, excess claim fees in Australia, deadlines for requesting examination, and change of name during the international phase and how that's recorded upon entering the national phase in Australia. So the first thing is the timing. Australia is a 31-month country, the same, for example, as the European Patent Office and New Zealand and India. So the Australian national phase needs to be effected by 31 months of the earliest priority date that's claimed in the international patent application. We would normally need instructions to enter the Australian national phase at least 3 days before in the normal course of things, but in an emergency we can enter the national phase on the same day as receiving your instructions. The requirements for national phase entry in Australia are pretty straightforward. There's no power of attorney requirement. There's no inventor's declaration the way that there is in the USA, for example. All that we need is information identifying the international patent application. So I would need the PCT number, or more preferably a copy of the published WIPO pamphlet. If the international patent application was lodged in a language other than English, then we're going to need an English translation, and importantly, we're going to need a verification of translation. Now, the verification of translation is just a statement that's signed by a person who is fluent in the original language and in English, and who can attest that the English translation is a complete and true translation of the international patent application, including any amendments that may have been made under Article 19 or under Article 34. And that certificate of verification doesn't have to be notarised or legalised in any way. It simply needs to be signed, and we don't need to have an original of it. A scanned and emailed copy or a faxed copy will suffice. Now, in Australia, there's no additional official fee for excess claims or for excess pages. So it doesn't matter whether the international patent application has got 5 claims in it or 50 claims. It doesn't matter whether or not it's got 5 pages or it's got 500 pages in the patent specification. The official fee for entering the national phase is exactly the same. However, where there is an excess fee that's payable is upon allowance, and it's very important to keep this in mind, because it can be a nasty surprise to realise that for each claim over 20, there is an excess official fee of $110 Australian payable. So if you have 50 claims in the patent specification upon it being allowed, then you're looking at an official fee payment of $3,300 in excess allowance fees. So that's really worth bearing in mind, and there are a number of opportunities for cutting down on the number of claims, either during examination or through filing a voluntary amendment at the time of national phase entry. It is possible to file an amendment at the time of national phase entry. However, if an amendment is filed then and examination is not requested, then you're looking at a fee of $250 Australian, which would not be incurred if the amendment was made when examination is requested. Sometimes people want to make a voluntary amendment upon entering the national phase. For example, they might want to make an amendment and then request publication of the amended claims because there's some sort of infringement issue that they're concerned about. But in general, if that's not the case, I'd suggest making the amendment at the time of requesting examination. The deadline for requesting examination is 2 months after a direction to request examination issues from the Patent Office. And there's no hard and fast rule as to when that direction will issue. It really depends on the workload in the examination section to do with the the subject matter of the patent application. But in general, you can expect to get a direction between 12 and 18 months after national phase entry. So the general deadline is 2 months after the issuance of a direction to request examination. You have to request exam within 2 months of that direction issuing, or alternatively, you have to request examination within 5 years of the international application filing date, whichever of those two things is the earliest. The fact is, though, that the Patent Office's policy is to issue a direction to request on all patent applications. So almost invariably, we work to the 2-month deadline after the direction issuing. Now, you can have a situation sometimes with an international patent application where during the course of the international phase, there's been a change in ownership of the international patent application. And the most common way that would occur is due to an assignment. So the original owner has assigned the international patent application to somebody else. Now, provided a request to record that change has been lodged with WIPO, say a month to 6 weeks before we enter the Australian national phase, the Australian national phase application will proceed showing the details of the new applicant. However, in my experience, if you enter the Australian national phase reasonably shortly after that request has been lodged with WIPO, for example, within 3 weeks of it having been lodged with WIPO, then upon entering the national phase in Australia, the Australian application may show that the owner is the original owner, not the new owner. But that can easily be sorted out. We can file a request to record the name change and lodge a copy of the assignment directly with IP Australia to get that sorted out very, very quickly. One other issue that I get asked about sometimes is renewals on Australian patent applications. For an Australian patent application, which is the national phase entry of an international application, the first renewal falls due on the 4th anniversary of the international filing date. And renewals, unfortunately, are payable annually every year after that. So Australia is one of those countries where you have to pay renewals before the application has been granted, in contrast to some other jurisdictions, like, for example, the USA, China, New Zealand, where you don't have to pay renewals until the patent has actually been granted. So, look, thank you for watching this, and I hope some of this information has been helpful. The sorts of things I've tried to tell you are the kinds of things that I look for when I'm helping my clients enter the national phase in overseas countries. If you have any questions about any of this material, please don't hesitate to shoot me through an email, and I'll be happy to reply and help as best as I can. Thanks again for watching.